Everyone, we're going to go ahead and get started with our community development meeting. Today's date is June 26, 2025. The time is 10:07 a.m. In attendance are Commissioners Eberline and Matari. I'm going to call this meeting to order. There's no chairman's opening remarks today. Are there any changes to the agenda? Hearing none. Poll for conflicts of interest. Any conflicts of interest?
No.
None here. First up is a public hearing, ZON 24-0009, JMAC. There's an asterisk next to it, and it's an action item. Director David Callahan.
Commissioners, I can explain. This is on your agenda because the newspaper made a mistake. It's the first time, to my knowledge, in 11 years that this has happened. But they printed the wrong hearing date. And so with the possibility that some person might have seen that and wants to make a comment, we've put this on the agenda. And so you should open up the hearing, check and see if there's anyone here that wants to talk. At your discretion, you could hear it now, or you could inform them that the actual hearing date is 7/10/25 at 10 in the morning. That's your call, not mine.
Well, without objection, I would argue we should have the actual hearing day as properly posted. But I will ask, is there anyone here who would like to speak about this particular hearing?
Or by telephone?
Anyone on the telephone? Anybody on Zoom?
We're not doing Zoom anymore.
Okay, final call. All right, then we will have this hearing on its advertised date.
That works. Thank you.
Next up is ORA 25-0004, Agricultural Protection Area Amendments. It's an action item. Director Callahan, I have you listed.
Yes, sir. Commissioners, this is necessary because the state law has changed. Interestingly, changed shortly after we adopted our first agricultural protection area ordinance, which the state law required. But the new amendment under the state law actually makes things easier for everyone. By that I mean, for instance, that the old state law said we had to change a map of record either in our comp plan or our zoning map, which would necessitate a public hearing, typically, in front of the Plan Commission and you. The new regs say that it just has to be a map. So we could do an overlay on our geographic information system, for instance. And then we're done. No public hearing, easier, quicker, more efficient. Similarly, the old law said that you had to make the decision on accepting a request for an agricultural protection area. The new law says that I can, or the person in my position. So again, easier, simpler, less costly. There's a few other little things in here, like it's under the new state law and in the regulations that Pat's drafted up and that are in front of you. The applicant can request for an agricultural protection area to actually be within an area of impact. Right now, that's not allowed. Or if it is allowed, I've forgotten how it works.
It wasn't expressly allowed or prohibited. Now it's
It's
expressly
clearly
allowed. Yes.
allowed.
Okay.
And then similarly, once land is in an agricultural protection area, the new law says that it won't be changed unless the designation expires because the owner chooses not to renew the designation or the owner chooses to remove it as is allowed by state law. So again, that's just a clarification.
Yeah.
And it also provides for an appeal procedure to the board of the director's decision.
So all in all, these are, in my view, all useful things and necessary by state law. So I hope that answers why this is before you.
Thank you. Any questions?
I'll ask a question later on.
All right. Well, since it's a hearing, I will ask, is there anyone here who would like to speak for these amendments? Anybody on the telephone? Going once. Anyone would like to speak for the amendments? Going twice. Okay. Anyone here who would like to speak against the amendments? Anybody on the telephone? Going once. Going twice. Anyone want to speak against the amendments? Okay, we have no one who wanted to speak for or against. What questions do you have?
David, does that impact what's going on down further south with on the tribe and that situation where people are trying to put different things in?
Not directly. I think
There certainly could be applications for agricultural protection areas within the reservation boundaries, but that's, I think the extent to which anything may be affected with respect to the tribe.
That's all I had there.
I don't have any other questions, so with that said, I move that we end public testimony and move into deliberations.
Second.
Commissioner Eberline,
Aye.
Chair Matari.
Aye. Well, from what I can tell, state law says we have to do this, and we're doing it. And so with that said, I'm good with it.
Excellent.
All right, well, then I'll make the motion. I move that we approve ORA 25-0004 Agricultural Protection Area Amendments.
So be it.
Commissioner Matari, Eberline,
So be it.
Chair Matari.
Aye, motion carries. Thank you. Next up, deliberations. Item number 3, MSF 25-0001 Revelstoke Ranch, and we have Vlad Finkel.
Good morning, Commissioners. For the record, Vlad Finkel with Kootenai County Community Development.
Could you speak up a little bit, Vlad?
Can you guys hear me now?
Yes.
Okay. For the record, Vlad Finkel with Kootenai County Community Development. This is a request for final plat approval of a preliminary decision of a major subdivision that the Board of County Commissioners approved in May of 2022. So the primary purpose of the meeting today is to assess and confirm whether the applicant has met all of the conditions of approval that were imposed in the preliminary order of decision by the Board of County Commissioners. The subject property is located 1/2 mile north of the intersection of Bruner Road and Old Highway 95, and just west of Silverwood. The applicants are proposing a 20-lot residential subdivision that will have Gem State Water provide domestic water supply and individual septic systems on each lot. The applicants have, since the original preliminary approval had gone in and constructed all the infrastructure improvements, staff had conducted a site inspection and confirmed both with the Highway District as well as Gem State Water that the applicant has complied with their requirements. The applicants have posted a 10% warranty bond for the improvements that are in place in case there are any deficiencies within that 12-month period. They will be utilizing that bond to fix it unless the applicant does it on their own. In that regard, the applicant has made all the infrastructure improvement requirements and bonding. The remaining conditions of approval were reviewed by staff thoroughly, and it was determined that they have complied with every condition. We have also confirmed that the CCNRs, or the documents that oversee the maintenance and upkeep of this, have been evaluated to be correct and consistent with the code requirements, and therefore we don't have any concerns with this final plat application. We request or we make a recommendation of approval. I don't have any further information to add unless you have questions for me.
Thank you. Questions?
No?
No. Just one question. The lots, the subdivision is consistent with adjoining properties? Lot size and development?
So a majority of the parcels to the south and west are of similar sizes. Parcels to the east is the Silverwood theme park.
Yeah.
So in that regard, a majority of parcels to the south, west, and north are.
Okay.
Why that query?
Why asking that question?
Yeah.
Just for continuity in the area. So it's all residential, all similar lot size and so forth. So
Cookie cutter.
I don't have any other questions. So your thoughts on that?
Let her rip.
All right, I move that we approve MSF 25-0001 Revelstoke Ranch.
Second.
Commissioner Eberline?
Aye.
Chair Matari?
Aye, motion carries. Next up, item 4, it's a business item. Authorization to proceed with amendments to Title 8 Kootenai County Code, Chapter 5, new Article 5.3, and associated definitions, wireless communication facilities. And Pat, did you want to take this?
Yeah, I can, and David can step in if need be. This is basically proposed in the wake of the couple of wireless communication facility cases we've had, including one I had an oral argument on just before this meeting. It would do a few things. First of all, it would up our current wireless communication facilities regulations date back to the late 90s. Since then, there have been several cases along with a major FCC order that have come about, and this would update our regulations to incorporate those that law that's developed since then. Also would ensure uniformity with our cities in the county, including Coeur d'Alene, Post Falls, and Hayden, all of which I based this proposal on. And as well as I also considered the Dalton Gardens ordinance that some people, members of the public, have pointed to as an ordinance that the county should adopt. I found that a little bit, it's consistent with this, but it's a little wordier and I think more complicated and unwieldy than the regulations Coeur d'Alene, Post Falls, and Hayden have in place. So I went ahead and used those three as the model as opposed to the Dalton Gardens model. One thing, if the county were to decide that they needed to retain an expert to evaluate an application, they will be able to do so and pin that expense on the applicant. That's something that's already in the city's ordinances. And it also, as far as development of FCC law, it also addresses something that the current regulation does not address, which is so-called small cells, which have a shorter time to make a decision on and certain unique regulations that apply to them. And so that would be covered as well. I won't say that this will automatically cause a denial to be upheld, but I think it does would give a much stronger basis for the defensibility of any denial of an application, especially one where we've retained an expert. So unless there are any other questions, of course, this does not bind you to approval of anything. It just would allow us to go forward through the process with public comment, the Planning Commission, and then come back to you for a final approval.
Any questions?
Yes. Who was challenging it and why?
Challenging which?
With the,
Telecommunications providers, frankly. And they were successful on the Potlatch Hill case. And we just had oral argument on the 4th of July pass case. And, you know, frankly, those pointed out the weakness of our current regulations.
Yeah, there were two situations where the board denied the applicant, which in this case were cell phone companies, the permit to put a tower on. And so subsequently, the county was sued. One of those cases we lost. The other one we're in process right now. And so these amendments would, in essence, strengthen the county's position should this board or future board deem the location of a tower inappropriate.
Yes, I would agree with that statement.
And otherwise, what's happening is the carriers are relying upon the mid-90s FCC statute that pretty much brute forces its way into the local jurisdictions and says, you better or else. And that's how it's kind of been playing out.
Good.
Yeah. I'm for it, but I just got the document without any background.
Understand.
So when is the next step going to occur if we say yes today?
We will schedule a workshop with the planning commission. You could certainly attend that if you want.
But when?
We'll
Like-
just we'll have to schedule. I don't know yet.
But like next week?
Immediately.
Next week or
In the
like
next
2 or 3
available
weeks?
month.
Okay.
It typically takes us about a month to get all the plan commissioners lined up.
Okay. So I would like to go through it and at least give you some thoughts if there are any,
Oh,
or ask
absolutely. You
some
can do that-
questions.
do that
So
anytime.
Right.
if I could ask a favor of you, which is if you don't hear from me, be a squeaky wheel and say, Bruce, do you have any thoughts on this?
Sure.
Before we
I
go to
can-
the next
yeah,
step.
I'll do that with all three of you.
Yeah, okay, perfect.
We could delay the plan
Yeah, all
commission's
three
public
of us.
hearing.
Yeah, well, that'll happen. So if there's no objection, you have direction to take it to the next step.
Thank you.
Okay.
Does that work for you, Commissioner Eberline?
Yep. It does.
I know
Okay.
Commissioner Duncan also had endorsed that.
Well, she was working with you before on this,
Yeah,
right?
Right.
Yeah.
I just wanted to mention that on the record.
Yep, okay. All right, well, that concludes our business. 10:25, meeting adjourned. Thank you.